Now, Justice Thomas wrote a lengthy dissent, totaling 90 pages. While the size doesn't make right, here I summarize what I think are the best arguments. The court decision in Dred Scott v. Sanford would have permanently denied citizenship to blacks as a subordinate and inferior class. After the Civil War, the Reconstruction Congress overruled Dred Scott, first with the Civil Rights Act of 1866, then with the Citizenship Clause of the 14th Amendment. Both the Civil Rights Act and the Citizenship Clause guarantee citizenship to persons born and domiciled in the United States, regardless of their race. Neither guaranteed citizenship to persons who were not domiciled in the United States. There's that word domicile again. I find this interesting for two reasons. First, the word domicile does not exist in either the text of the 14th Amendment or Senator Howard's explanation of the language and subject to the jurisdiction thereof. Second, because I see Justice Thomas's point when it comes to post-Civil War blacks. They were not citizens according to the courts, but they were permanent residents of the United States. Blacks were entitled to citizenship because they were Americans. They had no other homeland, owed no allegiance to any foreign power, and were subject to no other authority. This is a completely different situation from children of visitors or illegal aliens. The same could not be said for the children of foreign temporary visitors. Foreign temporary visitors were attached to their home country, lacked similar bonds to this country, and would not be called upon in a time of war. Americans, consistent with their settler ethos, believed that citizens were the people who called a place home. Accordingly, domicile, a person's legal home, played a key role in both state and national citizenship in America. A person was a citizen of the state where he had his domicile. When foreigners temporarily visited, their national character was unchanged. Such visitors were strangers, not subjects. A person born here but domiciled in a foreign land was therefore considered as much a stranger to the country as his father. Now, visitors do not live in the United States. They're visiting. And people who enter this country illegally do not have a legal domicile in the United States. So to be a citizen at birth, the child, or more accurately the parents, need to be subject to the United States, meaning someone with a duty to this country, or as Justice Thomas put it, could be called upon in a time of war. This was obviously Congress's intent in both the Civil Rights Act of 1866 and the Citizenship Clause of the 14th Amendment. Congress implemented the principles that citizenship follows birth and domicile in the Civil Rights Act of 1866 and then in the Citizenship Clause of the 14th Amendment. The Civil Rights Act guaranteed citizenship to persons who were both born in the United States and, as relevant here, not subject to any foreign power. The phrase "not subject to any foreign power" excluded from citizenship children of foreign temporary visitors who were subject to the power of their home nation. The Citizenship Clause, which the same Congress passed shortly after the Civil Rights Act, was understood to have the same meaning. It guaranteed citizenship to persons who were both born in the United States and subject to the jurisdiction thereof. A person was subject to the jurisdiction of the government of his domicile. Domicile was the foundation of jurisdiction over persons. So the clear intent of Congress is that not only someone be born in the United States to obtain citizenship, but that they have some legal relationship here as well. At the very least, that they are not subject to a foreign power. But that's not what this court said in its opinion. The court offers a different account. American citizenship, the court says, was based on medieval English feudal principles, according to which each person owed personal service to the lord of the soil as his master, a perpetual servitude that was born with the child and only ended in the grave. Americans, the court says, adopted this feudal principle as a rule of American citizenship with little fanfare. Then, according to the court, the Reconstruction Congress codified the feudal principle with the words "not subject to any foreign power" in the Civil Rights Act and subject to the jurisdiction thereof in the Citizenship Clause. Then, the court says the clause meaning was definitively settled by dicta United States v. Wong Kim Ark. Again, the court claims its interpretation, its opinion about the case, defines what the Constitution means. Their elevation of medieval English principles above the supreme law of the land, the law they took an oath to support, proves the bad behavior of so many of these justices. I guess they never learned in law school that they are a creation of the Constitution, not its master, which may explain Justice Thomas's conclusion. Now, as Justice Alito points out in his dissent, every step of this story is incorrect. The Declaration of Independence repudiated the foundation on which the British rule was based. From 1776 until the eve of the Civil War, the status of the rule in the country was unsettled. There is no evidence establishing that the Constitution's reference to citizens incorporated the British rule. And until the eve of the Civil War, there was little litigation about the meaning of American citizenship. Now, after the war, Congress finally adopted a constitutional provision, Section 1 of the 14th Amendment, making certain persons citizens at birth, but that provision differed substantially from the British rule. It specified that a person born here is not a citizen unless his allegiance to the United States is unimpaired by any obligation to a foreign power. Justice Thomas concludes, the court today takes the extraordinary step of holding facially unconstitutional the President's order excluding from citizenship the children of foreign temporary visitors and illegal aliens. In doing so, the court adds to the sad history of the 14th Amendment, which was designed and understood to secure equal rights for the freed blacks, but has instead been repurposed for political projects that the Reconstruction Congress did not support. Because many potential applications of the President's order are consistent with the original public meaning of the Citizenship Clause, I respectfully dissent.